Hi everybody, this is Brooks Lindsay. I'm the founder and editor of Debatepedia.org. I just wanted to walk you through some of the pros and cons today of one of more recent debate articles on Debatepedia. And this is on the Citizens United versus Federal Election Commission ruling by the Supreme Court, which was on January 21st, 2010. And this was a 5-4 decision by the conservative majority of the court in favor of unlimited corporate and union and advocacy group spending in elections. So it was based on a video submitted by Citizens United called Hillary the Movie, and this video was essentially a campaign ad, although the Citizens United group said that it was not. They thought that it was neutral and that it was fact-based and so forth, but the Supreme Court actually did rule that it was a campaign-style movie, but they ruled that that was okay, that this organization, Citizens United, could directly spend on this movie, and that was fine. And so the ruling, the broad ruling that the Supreme Court delivered was that now it is okay for companies and unions and advocacy groups and any other organization to spend unlimited amounts of money on campaign ads. Whereas before, what a corporation would have to do, or a union or an advocacy group, was that they would have to form a PAC, a political action committee that could put money then into that PAC, and then that PAC could spend a limited amount on campaign ads and so forth. But the ruling was really, on its face, primarily about free speech, or that's what the advocates were arguing. So that's what the 5 Supreme Court justices in the majority ruled for. So I'll give you some examples here. The main argument that free speech applies to corporate speakers as well as to individual speakers. So in the actual Supreme Court ruling, quote, government may not suppress political speech based on the speaker's corporate identity. No sufficient governmental interest justifies limits on the political speech of nonprofit or for-profit corporations. So another one in this argument, how we define it on Debatepedia, is ban on direct corporate funding is a ban on free speech. So in the actual ruling, 441Bs, that's the previous laws, prohibition on corporate independent expenditures, is an outright ban on speech backed by criminal sanctions. It is a ban notwithstanding the fact that a PAC created by a corporation can still speak, for a PAC is a separate association from the corporation. So it's interesting, in this argument they're actually including a sort of argument that, well, if PACs can spend on campaign ads, well, why can't a corporation? You know, why would you distinguish in terms of free speech between a PAC and a corporation? So we'll get to that. But I just want to keep on going through some of the main arguments that the majority was making. So another argument is that it's generally wrong to fine or jail citizens for political speech. So Justice Anthony Kennedy said, if the First Amendment has any force, it prohibits Congress from fining or jailing citizens or associations of citizens for simply engaging in political speech. So obviously, if you have this law in place that prohibits a company from directly spending, or a union or advocacy group from directly spending on campaign ads, then if they do so, you will have to fine them or imprison them, depending on the severity. So the argument is that's kind of an unfortunate situation for someone just speaking out, or maybe spending to speak out in a campaign ad. That the country shouldn't be fining or jailing people or companies for doing that, for speaking. Another argument, limits on corporate spending generally chill free speech. So the argument here is that if you have any restrictions on free speech and spending limits, that companies and organizations are generally going to avoid the potential of litigation. So they're going to try to kind of err on the side of being conservative as far as pushing the limits, because they don't want people to launch frivolous lawsuits against them just on the suspicion that they might be violating the law, even if in fact they're not. So it has a generally chilling effect on free speech is the argument that they're making. And another one, the First Amendment protects pamphleteers and big government, big corporations. So the point here is that free speech is supposed to apply across the board, not just to the lone pamphleteer, as they say it, but also to the large corporation or the large union or even the large bank with a lot of money. That free speech, there is no categorization of it just for the lone individual, the lone pamphleteer, that it applies to big corporations as well, or really wealthy individuals or really wealthy journalists, whatever. So you can't just draw lines is what the argument is that they're making. Another one, so limiting corporate spending is a slippery slope against free speech. So Chief Justice Roberts said that limitations on an anti-Clinton movie called Hillary the Movie before the 2008 primary election would lead to broader restrictions, quote, would allow censorship not only of television and radio broadcasts, but of pamphlets, posters, the internet, and virtually any other medium that corporations and unions might find useful in expressing their views on matters of public concern. So, slippery slope argument there. In addition, spending limits foster equal, not free speech. So from the Cato Institute, this is actually not really from the ruling, John Samples and Elia Shapiro wrote that restrictions on advertising were based on the idea, quote, that corporations had so much money that their spending would create vast inequalities in speech that would undermine democracy. However, to make campaign spending equal or nearly so, the government would have to force some people or groups to spend less than they wished. And equality of speech is inherently contrary to protecting speech from government restraint, which is ultimately the heart of American conceptions of free speech. So again, the concern in this argument is that the law, as I just before, was simply against corporations' free speech because they had so much money to spend that they might have bigger free speech, right? So the concern was the previous law was just trying to bring down the loudness of that speech and make equality among all the speakers as far as, how big their voices can be. The argument is, of course, that that's equal speech, not free speech, and that the Constitution gives the right to free speech. So we'll get to all this and the counter-arguments in a second. I'm just going to finish up on the essential arguments that the court was making as far as free speech goes. One is, why would you limit speech of corporations and unions but not others? So critically, what the concern here is regarding media. So media has the right, media corporations, newspapers, to essentially endorse a candidate, obviously write an article that endorses that candidate, and spend resources on essentially producing an advertisement, if you could call an editorial an advertisement. So we'll get to the implications of that, because there are definitely some counter-arguments there. As far as the counter-arguments on just free speech in general, so the main argument, counter-argument, is the right to free speech does not apply to corporations. So, quote, the court's blow to democracy, this is the article, the court's blow to democracy, New York Times editorial, January 21, 2010. The founders of this nation warned about the dangers of corporate influence. The Constitution, they wrote, mentions many things and assigns them rights and protections. The people, militias, the press, the religions, but it does not mention corporations. Most wrong-headed of all, in the Supreme Court's 2010 decision, is its insistence that corporations are just like people and entitled to the same First Amendment rights. It is an odd claim, since companies are creations of the state that exists to make money. They are given special privileges, including different tax rates, to do just that. It was a fundamentalist reading of the Constitution to say that these artificial legal constructs have the same right to spend money on politics as ordinary Americans have to speak out in support of a candidate.